Hello everyone. This is Utkarsh Mishra, and today we are going to discuss, or rather, throw light on Indian Contract Act. This session is not going to be a very exhaustive session on the concepts which are contained in the Indian Contract Act 1872. However, today what I'm going to do is to basically give you an overview of Indian Contract Act 1872 and what does this legislation really do, what does it deal with, and what are its primary features, and what are its important pertinent questions that this particular legislation tends to answer by means of the various provisions contained in it. See, Indian Contract Act is the short title of this particular law is Indian Contract Act 1872. So it is that older a legislation. And if you read the very preamble of the act, it says, whereas it is expedient to define and amend certain parts of law relating to contract in India. Okay. If you read the preamble properly, it nowhere it is stated that this sort of law is consolidating the law relating to contract in India. Certainly not. Hence, if you, by the bare reading of the preamble of the Indian Contract Act 1872, you can easily make out that this is not an exhaustive piece of legislation. It is a legislation which is trying to come up with certain definitions of the various concepts of contract, and obviously it is also at the same time amending the law relating to contract which used to exist prior to 1872. So we are talking about a time period which is prior to 1872, which means a period at the point of which we had English rulers in India, and we were not completely independent at that point of time. So obviously we were heavily influenced by English laws and British legal system. And even in that point of time, if you have read the legal and constitutional history of India, you might remember that the laws which were governing Indians in the time of the English people were not uniform in nature. So obviously there were certain customs and usages, but even for different people belonging to different religion, there were different codes, there were different codes. And that is how, the British was trying to administer people at that point of time. So Indian Contract Act 1872 was one such, you can say, one of the many first attempts uh, at that point of time to actually create a uniform legal structure which governs contracts, which creates a uniform contract law for throughout India. And hence, the very preamble of the Indian Contract Act 1872 mentions that it is, whereas it is expedient to define and amend certain parts of law relating to contract. So, as I said, it is not exhaustive piece of legislation. There is one more reason why one can justify as to why it is not an exhaustive piece of legislation is the fact that if you read the Constitution of India and if you try to locate the subject matter of contract in the Constitution of India, in terms of the seventh schedule, in terms of the subject domains in the three lists, you will find Indian Contract Act in concurrent list entry 7. So it is not a subject which is purely in the legislative domain of the central government or the union government to make a legislation upon. Hence, in India, even though Indian Contract Act 1872 seems to be the primary legislation governing the contract law in India, but at the same time, if you go to certain states which are very, very commercially active, for example, the state of Maharashtra, you will see some other pieces of legislation which also have been, implemented by the state of Maharashtra to suit the conditions of commerce which are akin to that state. So obviously, because of the virtue of entry 7 of the concurrent list of the Constitution of India, many states are able to also enter into this sort of exercise. Hence, it would be wrong to say that Indian Contract Act 1872 is the only an exhaustive piece of legislation in relation to law relating to contracts in India. Yes, it is the basic law relating to contract in India, or you can say that it is the most important brick in the entire edifice of the contract law of India. Hence, the beginning point is definitely Indian Contract Act 1872. So, if we talk about Indian Contract Act now, I think I should first take you to the very presence of the Indian Contract Act 1872. Uh, and in order to do that, I would just like to refer to the basic idea of contract. If you talk about contract, it is all about an agreement which is created out of an offer or a proposal which is made by one party and which is accepted by the other party on the basis of certain consideration, and that agreement is also legal under the presence of law. The moment that agreement is enforceable by law, it becomes a contract. So usually contract is very normally understood as a legally enforceable agreement. Now obviously that agreement can be oral in nature, it can be written in nature. Although owing to the modern complexities of business transactions, I suppose that this is pretty much logical that nobody in today's world, where there is a complex cobweb of commercial relationships, enters into oral contracts. So obviously, in practical life, we see that contracts are being implemented in the form of a document, and that's how they create it as a document under the Indian Evidence Act 1872, and it becomes a piece of evidence in the court of law also to showcase that there existed a contractual relationship. So nowadays, a documentary contractual relationship has taken over and it has become the most popular means of sustaining any business relationship. However, having talked about this basic idea of a contract, so if you see the very starting point of a contract, it is offer, acceptance, consideration, agreement, and then a contract comes into being. So Indian Contract Act also 1872 also is modeled is it's basically structured and modeled in the same logical fashion. It starts with the basics of contract. It starts with the basic principles which govern the formation of contract, and then it enters into the second domain, which is the factors which implement or which impact the formation of the contract. And obviously, over the course of this discussion, I will be throwing light on what are those factors. Then it enters into the limitations on the freedom of contract, and basically talking about what are the issues and challenges with respect to creation of contract and which sort of contracts are not allowed legally to be created in Indian legal system. And then of course it moves down to other areas of breach, termination, damages, and etc. etc. So there is obviously a logical fashion in which the Indian Contract Act is also modeled. However, at this moment of time, I would like to divide the discussion, or you can say divide the overview of Indian Contract Act into two parts. If you talk about the first part, I would like to classify the first part starting from section 1 to section 75. Basically, section 1 to section 75 is the group of provisions which is, in most of the books you will find that it is popularly referred to as a group of provisions referring to the general principles of the contract. And yes, exactly that's what that particular group of sections does. Then sections 76 to 123 used to exist, these group of sections used to exist in the Indian Contract Act earlier, and those provisions were in relation to sale of goods, because sale of goods is also a type of a contract wherein goods are being sold, and then a value is being received by the seller for the sale of certain goods. However, those group of sections, section 76 to 123, they were basically removed from Indian Contract Act by the repealing provision of the Sale of Goods Act 1930. And if I'm not wrong, it was Section 65 of the Sale of Goods Act 1930. And by the very virtue of Section 65 of Sale of Goods Act 1930, 76 to 123 was repealed. And the very purpose of this repeal was basically to ensure that we have an exhaustive piece of legislation concerning sale of goods in place. And because 76 to 123, those sections were not really sufficient to cater to the needs of business transactions concerning sale of goods in modern times. And that is why this possible amendment was made in the Indian Contract Act. So that was one, sort of repeal which happened in Indian Contract Act. Then we have sections beginning from 124 onwards to 238. It continues till 238. And then those particular set of provisions I classify in part 2 of the contract, because these set of provisions basically create a specific types of contract. They basically legally recognize a specific type of business transactions, which I will come to and I will briefly discuss and touch upon in a short duration. And after section 238, section 239 to 266 also used to exist in the Indian Contract Act, which was also repealed. Those group of provisions were also repealed by the Indian Partnership Act 1932. Basically those set of provisions, as you might be able to infer, they were about partnership. And the same and similar reason and logic was given for the same amendment, that the set of provisions contained starting from 239 to 266 was not really sufficient to cater to the needs of partnership business in India. And we needed an exhaustive piece of legislation on partnership, and that's why that second large repeal was made in Indian Contract Act 1872. So now, at current moment, we do not have, apart from these two major repeals, we do not have many other amendments in Indian Contract Act 1872. Unlike other pieces of legislations, you might be reading the Grandnam of our legal system in India, the Constitution. It has experienced so many amendments. However, Indian Contract Act 1872, apart from these two large repeals that I talked about, did not suffer many amendments except for 2 or 3 smaller amendments. And they were not very, I would not say very substantive amendments in terms of the impact that they would create. So that is the basic structure of the Indian Contract Act 1872. So we have section 1 to 75, and then we have section 123 to section 238, and that is the only structure, that is the only set of provisions we have currently in Indian Contract Act 1872 today. So this is how I divided the Indian Contract Act into the two parts. First part, as I said, was general principles of contract, starting from section 1 to 75. If you talk about the general principles of Indian Contract Act, as I said, it begins from the very basic definitions of proposal, acceptance, consideration, voidable contracts, void agreements, etc. Obviously, the word, as I said, the terminology that is used in Indian Contract Act in place of offer is proposal. So we have not used the word offer, we have not defined the word offer in Indian Contract Act. We have rather used the word proposal. And jurisprudentially speaking, there is no set of difference between offer and proposal. It can be interchangeably used. So it is just a matter of practice and the matter of the kind of legal system that we are in, and that's how we did, because our legal system was primarily dependent on the legacy that the British legal system created for us as colonized nation. So we depended on that sort of terminology. So the impact of that colonization is still seen in many legislations, including Indian Contract Act 1872. So after talking about offer and acceptance, there are provisions relating to consideration. So I will say that firstly, the Indian Contract Act has talked about the very basic process of the formation of contract, which includes offer, acceptance, consideration, finally agreement, and that agreement has to be legally supported. It has to be legally recognized. All right. Now, one very important aspect of formation of contract is communication. Communication of offer, communication of acceptance, and that is how, because ultimately, when you are giving an offer and when you are accepting the offer, that offer and acceptance has to be done by certain mode. Either it can be in oral form or it can be in written form. If it is in oral form, it can be in when the parties are in direct presence of each other, or when the parties are sitting at a distance to each other and talking over telephone, or talking over, let's say, WhatsApp Messenger, or talking over Facebook Messenger, or any other online message conversation app. Similarly, if the parties are entering into a contract in a written through a written document, that can be either in the direct presence of the parties, or it can be again when the parties are sitting at a distance to each other. So it can be by means of post, it can be by means of email, or it can be by means of SMS or text, etc. So, all sorts of those discussions of smart chatting these days, which we really enter into, all of us are actually using those smart chats in various forms. They come into it when we talk about the communication of offer and acceptance. However, I would like to mention here that being a very older piece of legislation, Indian Contract Act only talks about, focuses about, has contained provisions about postal communication, and has, because at that point of time in 1870s when the contract law was being developed, and I think some of you might be able to relate to it, post was a very popular means of communication. In fact, it was the only means of communication when telephones were not there. And even when the telephones came, even then the post remained for a very long period of time. And even till date, lot of offers for jobs, employment contracts are being sent by official posts by government bodies and by other sort of institutions. So postal communications still are relevant in today's times. However, if we talk about communications by any other means, as I said, by social media, by online platforms, either by written chats or by online video conferencing calls, where you are even though able to see the other party, but you are still talking, you're not writing. It is still is an oral conversation, right? So the contract which is created out of it is also oral at that point of moment, unless of course the parties have decided to cull it down into a written document. So all those sorts of situations and peculiarities, they have not been primarily dealt with Indian Contract Act. That is the limitation of Indian Contract Act. Also, the very legal recognition to the electronic contracts is not contained in Indian Contract Act. So as I said, it's an older piece of legislation, hence obviously it needs a lot of amendments today, because we have actually grown in terms of business and the types of transactions. So the legislation definitely needs amendment. But currently it is the Information Technology Act 2000, Section 10 of which, 10 and 10A of which are really concerned about formation or legal recognition of a contract which is formed on an electronic medium. So there is no provision in Indian Contract Act, but there is a provision in Information Technology Act 2000 which recognizes electronic contracts. As I said, you need to refer to Section 10 and Section 10A of Information Technology Act. So that is one thing. And having said this, the second important aspect of provisions contained in Indian Contract Act is the factors impacting the formation of contract. As I said, the very first thing is the process, understanding the process of formation of contract. The second step is to understand the factors impacting the formation of contract, and those factors are consideration, which has been dealt with under two very important sections of Indian Contract Act, Section 2D and Section 25. So consideration is something which has been discussed very significantly in Indian Contract Act. Then coming to obviously, drawing, or you can say inferring more principles from the concept of consideration is the principle of promissory estoppel. Now, even though there is the term or the expression promissory estoppel has not been used by Indian Contract Act 1872, however, it has been read into the sections of consideration by the Supreme Court, and it has been discussed at length, and it has been interpreted as a part and parcel of the Indian Contract Act 1872 only. Then other factors impacting the formation of contract are free consent. As I said, obviously, when you are entering into contract, two individuals are entering into contract, or firms or business bodies are entering into contract, they should enter into a contract with not only by giving their consent, but by giving their free consent. So your consent should not be vitiated by any sort of coercion, undue influence, fraud, misrepresentation, or mistake. And all these five vitiating factors have also been discussed under the Indian Contract Acts, starting from sections 15, 16, 17, 18, 19, 19, 8, 20, 21, 22. So you will see these sections dealt with in the Indian Contract Act very significantly with proper illustrations. Now, having talked about the factors impacting the formation of contract, it is really very much relevant to talk about the limitations on the freedom of the contract. So you must understand that, and you will find this saying in almost every book which has been written on contract law in India and abroad, that every agreement is not a contract, but every contract is an agreement. All right. So that's the essence of this third section which I'm talking, or this third domain of discussion of contract law that I'm talking about, factors impacting the limitation of the freedom of contract. So yes, everybody, as far as our right to enter into contract is concerned, our right to enter into a trade, occupation, or a business is concerned, that is definitely, you can say, guaranteed as a fundamental right by a Constitution of India. But yet again, this right cannot be absolute. Hence, various types of contracts, various types of business transactions have been declared to be illegal, unenforceable in the court of law in the Indian Contract Act itself. So when I refer to those set of provisions, I'm actually referring to factors, or you can say I'm actually referring to limitations which are put on the freedom of contract. So for example, you are free to enter into a contract for a business relationship, but A cannot contract with B, giving wherein B is being made, where B is being paid money as a consideration to kill another person, which is C. Why? Because killing somebody at under the Indian legal system is already a crime. It is against the public at large. It is something which is against public policy. It is prohibited. So this is just one instance of a contract which cannot be allowed to legally sustain the parameters of contract law, which cannot be allowed to really exist. Similarly, there are different set of provisions starting from section 25, 26, 27, 28, 29, 30. We have talked about, in the Indian Contract Act 1872 has talked about contracts relating to restraint of trade, restraint of marriage, restraint of legal proceedings, contracts which are against public policy, immoral agreements, very, very important aspect of contract law in India, even till date. The wagering agreements, all those sort of agreements have been declared to be void. They have been declared to be unenforceable. All right. Also, I must tell you that while you read the sections of Indian Contract Act, you will actually see that this term void, voidable, it has been used, quite often in Indian Contract Act. So, and the expression void ab initio has never been used in Indian Contract Act. So you will find this discussion on void ab initio something which is not enforceable from the very beginning. Void ab initio, which is not enforceable from the very beginning. You will find the commentary on this sort of discussion in books, but you will not find this expression in Indian Contract Act. That does not mean that Indian Contract Act does not recognize what is void ab initio. So obviously, a contract which is against public policy is void. That means it is void ab initio. All right. And then there are certain contracts which become void after a contract is validly entered into. Those are also cases which have been discussed under Indian Contract Act in the form of uh, frustration of contract, Section 56, which we in India we popularly refer to as doctrine of supervening impossibility or contingent contracts. So there are certain cases of contracts which are initially very much valid, but after some time, due to certain reason, they become void. So those classes of contract are also discussed and classified under the Indian Contract Act 1872. So this is the third element of the general principles of contract, that is limitations on the freedom of contract. And then there are provisions containing discharge of contract. And when you talk about the concept of discharge, it is simple. It simply means a time when a contract comes to an end. A time, discharge refers to a time or a situation or a moment when the contract comes to an end, or when the obligations of parties under a contract are terminated or are over or are exhausted, and when the parties are no more under any sort of obligation to perform any obligations under the contract. So that is referred to as discharge. So there are various provisions of discharge they have not directly referred the term discharge in many provisions, but almost all those provisions refer to the concept of discharge in great detail. And discharge can happen through various modes: by performance, by anticipatory breach, by breach, by performance of reciprocal promises, and by death of parties. Okay, so there are so many situations: by novation, alteration, rescission, accord and satisfaction. All those conditions have also been discussed under the Indian Contract Act in great detail. So that is the fourth element of the general principles of contract. And lastly, the very last element, because having talked about formation, process of formation, limitation, and then discharge, the only thing that is remaining is talking about restitution, breach, and damages. So there are provisions relating to restitution, specifically talking about Section 64, Section 65 of the Indian Contract Act. All right, and then there is a full chapter under the Indian Contract Act on quasi-contractual relationships or relationships resembling contracts. So quasi-contractual relationships have been discussed, wherein the parties never intended to enter into a contract, but by virtue of equity and fairness recognized under law, those contracts are deemed to be contractual relationships so that a party is not unjustly enriched. So the cases of minor being supplied by necessaries by one party out of his own pocket, the situation where a person kind of uses the goods belonging to another. So all those cases have been discussed in great detail from section 68 to 72. So those are the cases concerning quasi-contracts. And obviously last part of the contract, as I said, is about breach and damages. And this, section of the Indian Contract Act still remains very much relevant even till date. That is section 73, 74 and 75 of the Indian Contract Act. 73 talking about the process of determination of damages when the damages are not specified in the contract, which means we are talking about unliquidated damages, and the whole concept of remoteness of damages, calculation of damages in cases where the damages are not stipulated for. The section is very much elaborate, and so many illustrations are given in section 73. Section 74 is talking about stipulated damages, or you can say liquidated damages, and penalty in contracts in terms of security deposits, or in terms of interest which has to be paid over a money amount. All of that is covered under section 74. And then section 75 is obviously a right which is given to a party for rescission of a contract when the other party is in the situation of breach, and the right to claim compensation from the other party has been also recognized under Section 75. So these three set of sections basically determine, or you can say that they have created a good amount of literature available for today's lawyers and today's generations to understand as to how to assess damages and how to assess damages in situation when the damages are not prescribed by the parties, and also when the damages are prescribed by the parties. So those sections are very much detailed. Now, all this is part of the, you can, as I was saying, it's all, this discussion is part, I club this discussion as part one of the Indian Contract Act. So you will find all this discussion under sections 1 to 75. Then coming to sections 124 onwards, 124 onwards and ending at 238, there are specific type of contracts which have been recognized. The contracts of indemnity, the contract of guarantee, contract of bailment, contract of pledge, and contract of agency. All right. So even though, you can say that sale of goods and partnership is also special type of contracts, because the moment we start talking about specific contracts or a special type of contracts, we are assuming that there is something different about those business relationships. There is something different about those contractual relationships, and that is why they are called as a special contracts. So under Indian Contract Act, these 5 types of business relationships rather have been covered, and then the other 2 types of specific contracts are covered under sale of goods and partnership, and now we have Limited Liability Partnership Act, and then there are obviously contractual relationships in many forms. The Companies Act 2013 is also fundamentally based on contract law, and obviously then securities law is there, security contracts are there, so many other contractual relationships are recognized under our legal system. All those can be referred to as special contractual arrangements. Now, why indemnity, guarantee, bailment, pledge, and agency? They still remain very fundamental types of business relationships, because nowadays you see that even if there is a normal contract, very simple contract between 2 parties, there is always be an indemnity clause in the contract, or there might be an agency clause. There might be a clause relating to guarantee transaction or guarantee agreement under that. All right. So nowadays the transactions have become so complex that you cannot actually respect the sanctity of contract, or you can say you cannot assure yourself that your contract will be performed unless and until there are certain miscellaneous provisions, like provisions relating to indemnity, guarantee, agency, liability of agents, and all of those. So in a way, if you see, because of the modern complex relationships, agency as such has become the grand rule for actually very successfully being able to create a very easy legal climate for many good big business houses to sustain in a legal system. So the fact that big business houses are being able to set up their corporate bodies here and there in India and abroad is primarily because of agency, and it is primarily because of the recognition of agency rule, and primarily because of the recognition of the liability of agents and liability of obviously principals. So agency is one such fundamental business relationship which cannot be avoided while studying Indian contract law, and hence agency has been dealt in a great detail under Indian Contract Act. So you will see those sections, and those sections start from around 170 and they end at around, not at 170, 181. 171 is basically pledge, and then after 171 we have certain other provisions of pledge, 171, 172, 3, 4, and then we have provisions relating to agency, real provisions relating to agency starting from I think section 181, 182, and then they go until 238. So there are a great deal of provisions. Similarly, when we start from section 124 onwards, section 124, 125, 126, 127, 128, 129, 130, 131, 132, and then so on and so forth. These are the provisions which talk about the issues of indemnity and guarantee, which are again very very fundamental and very common type of clauses relating to indemnity and guarantee are being inserted in every commercial business transaction in the today's world, and hence those provisions are very important to be read. And then obviously bailment is also covered under Indian Contract Act. Uh, the concept of bailment obviously is relating to the idea wherein you are basically giving your goods, because bailment cannot be for immovable property, it is only for movable property. Hence, goods are only the subject matter of bailment. So when you are giving your goods or when you are giving the possession of your goods to other party for a certain period of time and for certain purpose, and once that time period is over, the goods are to be returned. Now this type of contractual relationship is also very very much important because it is very much common in our day to day lives. So the example of you giving your clothes to a dry cleaner, and even though it is on payment basis, doesn't matter, but it is actually bailment. You are exercising your bailment rights, you are actually entering into a bailment transaction. So you going to a dry cleaner and giving your clothes for dry cleaning, and then dry cleaning keeping the possession of those goods for a certain period of time, and then returning, working upon those goods and then returning those goods, that is also a sort of bailment contract that you have entered into. So obviously all these types of business relationships, as I said, indemnity, guarantee, bailment, pledge, agency, they are very common sort of business relationships. So as I said, nowadays in most of these contracts, business contracts, you will find the provisions relating to either of these special relationships, because they try to somehow they try to assure and ensure that your contractual rights are protected. So as I said, for example, indemnity and guarantee. Indemnity is all about being undertaking a promise to basically indemnify someone from losses. So insurance, which is very very common business relationship that we all enter into, but we little I think we a common man would not really know that an insurance contract is actually an indemnity contract. It is based out of the principles of indemnity. Hence, it is very, very important to understand the idea of uh, indemnity of contracts, because, as I said, I gave you the example of one of the very popular modes of indemnity in modern times, that is insurance. Similarly, guarantee contracts. Guarantee contracts are those contracts wherein a third party gives a guarantee for a party, either to discharge, uh, basically to discharge the obligation of that party. Now, that obligation can be in the form of payment of money, and that obligation can be also in the form of performance of a promise. Now, that is also very common because you might have heard about bank guarantees. So, bank guarantees, guarantees given by financial institutions, guarantees given by third party individuals, all those are situations which are based on the fundamentals of guarantee. Hence, these are some very, very pertinent sections contained in Indian Contract Act. So, my idea was in this session to not tell you in detail. In fact, I have not dealt with anything in this session in detail about the concepts of Indian Contract Act, but I have rather talked about the way the Indian Contract Act is to be understood, and its structure, its parts, and what does it really cover. You must have also understood by now as to what are its limitations. As I said, the Indian Contract Act needs several changes at the moment because it doesn't cater to so many situations. It doesn't contain rules relating to standard form of contracts, electronic arrangements. It doesn't contain rules relating to communications over modern modes of communication like social media. All right, and then so many other provisions. That's a separate subject matter. We will definitely have a discussion on the possible ways in which Indian Contract Act 1872 should be reformed. However, this session, the whole idea of this session was to just give to the audience only an overview of what Indian Contract Act 1872 does, and we will be back by uh, more sessions on specific topics and specific concepts of Indian Contract Act, and again related legislations, or rather sister legislations like sale of goods, partnership, companies, other limited liability partnership, etc., etc. We'll do the sessions very shortly. I hope this session was informative for all the audience. Thank you so much. And if you have any questions and if you want any specific session on any specific topic, please comment in the box, and we would be really happy to deliver another good session for the audience in that respect. Thank you so much. I thank you all on behalf of the Center for Legal Education. Thank you so much.